Hi everyone, my name's Allison Grosz. I'm an attorney and a partner with Hemrick O'Malley, PLLC in New York City. Today I want to talk about a recent change from the beginning of August that has taken place from the Board of Immigration Appeals, specifically as it relates to how people are eligible for release from ICE detention while in removal proceedings. Now this is going to be a little bit nuanced, so I'm going to keep it as simple as possible. On August 4th, the Board of Immigration Appeals made a decision in a case called Matter of Akhmedov that said that the Department of Homeland Security, or DHS's, recent arguments that certain people who entered the United States illegally and are therefore not eligible for release from immigration detention while they are in removal proceedings, according to the BIA, could now possibly be found eligible for release from ICE detention while they are in removal proceedings. Let's give a very brief and very simple background for a rather complex issue. In recent months, the Department of Homeland Security has argued in immigration court, specifically in detained cases, that a person who entered the United States illegally is subject to mandatory detention and that the immigration judge does not have jurisdiction or authority to release certain people from immigration detention while they are in removal proceedings. This mandatory detention provision of the law, also called the Immigration and Nationality Act, has always applied specifically to people who have been paroled into the United States, as well as, of course, some other people who are subject to mandatory detention. Well, in recent months, DHS has argued in court that the immigration judge does not have authority to release other people who have entered the United States illegally from immigration detention during the removal proceedings. This rule, DHS argued, applied to people who were not paroled into the United States, but who entered unlawfully through other means. Now, they were arguing for several months since the beginning of the Trump administration that immigration judges do not have authority, as they always have been determined to have authority, to release people from mandatory immigration detention. And on August 4th, the BIA decided that, in fact, immigration judges still do retain jurisdiction or authority to be able to release people from immigration detention who have not been paroled into the United States, so long as those individuals otherwise qualify for release from immigration detention. A lot of people who have had bond hearings before immigration judges for the last several months and who have been determined to not be eligible for release from bond because the immigration judge decided, with DHS's arguments, that they did not have authority to release those people, well, those people may now be eligible to ask for another bond hearing or a redetermination of their custody based on the Board of Immigration Appeals decision in what's called Matter of Akhmedov that was decided on August 4th, 2025. So, with this being said, us here at Hemrick O'Malley represent people in detained cases, both mandatory detention and, of course, non-mandatory detention detained cases, as well as in all other forms of immigration proceedings, removal proceedings, and any applications for relief. You can feel free to find us online at hemrick.law. You can call us at 833-848-7838. We're happy to answer any questions about whether you or a loved one may be eligible for a custody redetermination proceeding, or whether or not this new rule from August applies to you. Until next time, I look forward to talking to everyone soon.